Welcome to Las Vegas Business, Bankruptcy, and Construction Law Podcast.
Hey everyone, welcome into the first episode here of the Las Vegas Business, Bankruptcy, and Construction Law Podcast, where attorneys Tony May and Micheal Brock unravel the complex landscape of business bankruptcy and construction law. I am your host, Mike Leon. You know, from drafting bulletproof contracts and resolving mechanics liens to navigating Chapter 11 bankruptcy, complex business litigation, Tony and Micheal bring real-world experience to the legal front line. Today's episode, Mike's going to be sharing his vast experiences on the business lifeline, whether it be Chapter 7, Chapter 11, Chapter 13 bankruptcies. Michael's going to explain all of this and break this all down for us. Micheal, it's good to see you and good to meet you here on this first episode. So I know your background, you have an MBA from Penn State. So we're going to get into a little bit of that, but a little bit of the legal side. How does a business owner's financial data dictate whether they should pursue, whether it be Chapter 11 reorg or maybe a Chapter 7 liquidation?
Hey, thanks for having me, Mike. So that's a really good question. Whether a business should pursue Chapter 11 or Chapter 7 is going to largely be dictated by what the financial data says about the business's economic viability, its capital structure, and creditor recoveries. Courts don't really apply a strict formula, but EBITDA, or earnings before interest, taxes, depreciation, and amortization, as well as leverage, liquidity, and asset values, are going to strongly influence both legal feasibility and practical outcomes in bankruptcy. Some of the ways to think about and analyze which form of bankruptcy makes sense include, is this business worth more alive than dead? If the answer to that is yes, then Chapter 11 is going to make sense. If no, then you're probably looking at Chapter 7. And a lot of those financial metrics are going to help in answering this question. So first of all, we want to look, can the business support itself? EBITDA approximates operating cash flow that's available to service debt, to fund the business operations, and to support a plan of reorganization in Chapter 11. If you've got positive EBITDA, or if it's near positive, then Chapter 11 is probably a feasible option. But if EBITDA is consistently negative and it won't turn positive even after certain contracts are rejected, or the business is looking at selling assets or making structural changes, then the business should probably be looking at Chapter 7. If a business has a high debt to equity ratio, this doesn't automatically mean that Chapter 7 is preferable over a Chapter 11 filing. What really matters is if the debt can be restructured, if it can be crammed down, or possibly converted to equity. Business value to secured debt ratio is also a very important indicator. By that I mean, if the debt to equity is high, but the value of the business exceeds the secured debt, and the debt can be restructured, crammed down, or converted, then that would indicate that Chapter 11 might make sense. Otherwise, a business should probably consider Chapter 7. You also want to look at liquidity in the business and its cash flow timing. Chapter 11 does require cash to fund ongoing business operations, like payroll, vendors, insurance payments, other operating costs. And of course, there are the professional fees that are associated with the bankruptcy. If a company has positive or manageable operating cash flow, or if it has access to financing, then that would support the filing of a Chapter 11. On the other hand, if the business has very little liquidity and or no access to any financing, then Chapter 7 is going to be recommended. Finally, you want to look at the value of the business's assets. Chapter 11 is going to be favored if the going concern value exceeds the liquidation value. By that I mean the business is worth more alive than dead, like I talked about at the beginning of the question here. Also, if the business has some intangible assets that are material, such as brand names or contracts, or a very talented workforce, then that too is going to indicate that Chapter 11 might be a good option. On the other hand, Chapter 7 is going to be favored if the business assets are more commodity-like, things like inventory or equipment, If there's very little goodwill in the business, if it doesn't have transferable contracts, and if the value of the business is going to collapse without ongoing business, again, you're probably looking at Chapter 7 being favored over Chapter 11.
Yeah.
So I know that's a long answer to your question, Mike, but
Yeah.
those are kind of the things that we would look at in determining whether or not a business owner should file Chapter 11 versus Chapter 7.
No, and it's good insight, Mike, into all of this. And I like the better dead than alive analogy with the business. But let me ask you about small business owners that some that could be listening to this and maybe they're operating as sole proprietors. Let's talk about Chapter 13, because I mentioned in the intro. Well, first explain that, but why also might a Chapter 13 repayment plan be superior to a Chapter 11 reorg, even though the Chapter 11 is kind of traditionally known as the business chapter?
Yeah, so Chapter 13 is, especially if you're a business owner or you're a sole proprietor, then Chapter 11 is a legally available option, but sometimes it's not it just doesn't make sense economically. Chapter 13 is often considered a consumer chapter, but it can at times be it can be far superior for small business owners whose business and personal finances are more or less inseparable. The reason for that is that as a sole proprietor of a business, you have no separate legal existence from the business. So business debts often mean personal debts. Business assets are often also personal assets, and your personal income can sometimes be funding the business and vice versa. So Chapter 13 will recognize this reality, whereas Chapter 11 really does not. Chapter 13 is also a much more affordable option. The legal fees are relatively modest in comparison to Chapter 11. You don't have any disclosure statements or monthly operating reports in Chapter 13 like you do in Chapter 11. You don't have a creditors committee that you're going to have to deal with in Chapter 13. And the trustee oversight in Chapter 13 is much more streamlined. So practically speaking, Chapter 11 fees will also often exceed the business profits, and that makes reorganization somewhat self-defeating.
Okay, so I want to move over and get a little bit more in the weeds here. Let's talk about the subchapter 5 part of Chapter 11. Can you talk a little bit about how that's kind of changed the landscape for small businesses in Nevada?
Yeah, I would say that subchapter 5 of Chapter 11, so it is part of the Chapter 11 filing scheme under the Bankruptcy Code, but it's kind of been specialized. It was created by Congress in 2019, and it has really shifted the restructuring landscape for small businesses, including those here in Nevada. It offers a genuinely faster, cheaper, and more practical alternative to traditional Chapter 11 in many cases. It's not a universal fix, but the empirical results and structural changes do indicate that very often it will live up to its designed goals for eligible businesses. So, like I said, Subchapter 5 was created by Congress in 2019. It was created to make Chapter 11 more workable for small businesses that historically just were unable to afford the time, the expense, and the complexity of traditional Chapter 11 filings. There are certain qualifications that need to be met, or eligibility standards that need to be met for Subchapter 5. You have to be a small business. Your debt has to be, right now, the limit on debt is about $3 million. But the advantages, some of the advantages of Subchapter 5 is, again, you don't have any creditor committees in most cases. The requirement for the separate disclosure statements has been done away with, and there's a quicker timeline to get a plan of reorganization on file with the bankruptcy court. There's the other advantage to Subchapter 5 is that you don't have to pay quarterly U.S. trustee fees like you do in a normal Chapter 11. And the court is empowered to confirm plans of reorganization without creditor approval, as long as the plan is feasible and it is treating your creditors fairly. So again, all these changes were designed to reduce both costs and time in bankruptcy while preserving a business's value. Now, Nevada's business climate includes many small enterprises, and traditional Chapter 11 was often too burdensome. So for many Nevada business owners, they have debt levels that will fall within the eligibility requirements for Subchapter 5, and that makes Subchapter 5 a very attractive option for them. This gives, again, Nevada business owners the access that they need to meaningful restructuring tools that just really weren't practical before.
Yeah.
But I would add, sort of as a caveat, that Subchapter 5 is not a guarantee success vehicle. So you need to have realistic planning. You need to strategically execute that plan. And if you can do those things, then you will greatly improve your chances of success in a Subchapter 5.
So, Michael, let me ask you, because I know a lot of business owners have personal guarantees a lot of times on like their commercial leases or even loans that they've taken out with the business. How do you guys prevent a business's Chapter 7 liquidation from triggering a real personal financial crisis potentially for the owner?
Yeah, that's a great question, and a very real fear of many business owners, because, as you said, a lot of these agreements that they enter into do require that they provide some sort of personal guarantee. The short answer to your question is you really can't eliminate the risk entirely, but you can try to contain it, you can try to sequence it, and you can try to plan around it so that a business Chapter 7 filing doesn't automatically wreck that owner personally. So the first thing to realize is that a personal guarantee will survive a business Chapter 7 filing. When that company liquidates, the creditors can, and they often will, pivot straight to the owner of the business. So the goal with the Chapter 7 isn't to file without any type of consequences. Instead, the goal should be to control any damage, make sure that you're using the right timing, and try to use what leverage you can to come out with an optimal solution. So generally what we want to do is we want to separate business failure from the personal balance sheet as quickly as possible. By that, I mean, we want to make sure that you're keeping a strict separation between the business and your personal finances. Try not to commingle your funds. We want to see you paying yourself a reasonable salary or some sort of compensation, and make sure that it's documented. Try to avoid any last minute transfers or moves to clean up things, because that's really just going to complicate things. And what you're going to find is that once the business does file bankruptcy, your trustee is going to come in and they're going to claw back a lot of those transfers. And then finally, we want to make sure that the owners do not personally reaffirm any of those business debts, because then they're just putting themselves further in jeopardy and on the hook for those business liabilities. Yeah. We also recommend that you try to negotiate personal guarantees before the business files the bankruptcy. You can sometimes settle these personal guarantees at a discount. You might also be able to convert a personal guarantee into a lump sum obligation into some sort of a payment plan. If you do things in the right sequence, that can be helpful, and it can be very important. Oftentimes, this means that filing the business bankruptcy is done first, and then you file a personal bankruptcy later. But sometimes it also might make sense to file a Chapter 13 personal bankruptcy before you shut down the business. With a personal Chapter 13 filing, you can stop any collections on the personal guarantees. You can set up some form of a structured repayment over a 3 to 5 year period, and you put your personal assets under the protection of the bankruptcy stay. And finally, it kind of gives you some time to stabilize your income once you're looking at the shutdown of the business. It's also helpful to keep in mind that in Nevada, we have some rather generous exemptions. That means that oftentimes personal assets are going to be very well protected. So for us, we see a successful outcome involving, number one, a clean shutdown of the business. Number two, personal assets being largely protected. Three, the guarantees either getting settled, discharged if possible, or maybe structured in some sort of a payment plan. Four, some kind of there might be some possible hit on your credit, but it's nothing that you can't recover from. And then finally, keeping your income pathway intact. So the secret to getting this right is to have the right professionals involved. Someone who handles both business and consumer bankruptcy, who is familiar with negotiating on personal guarantees, and who understands local bankruptcy judges and trustees, and in my opinion, is comfortable in telling you that right now is not the right time to file.
Yeah. You know, Micheal, as we kind of land the plane on this episode, it funnels perfectly into the follow-up, but I want to ask you kind of a one-off on it. So when you're looking at the current business environment in Las Vegas right now, you mentioned about getting trusted professionals involved in this, but what's kind of like one of the single most common mistakes you've seen business owners make when they wait a little too long between filing either 7, 11, or Chapter 13?
Yeah, a very consistent mistake that we see with business owners is that they wait until the business is already in a crisis mode, where they've got creditors who are coming after them. There have been liens that have been filed. Assets are disappearing. Cash flow is diminishing. And so in that situation, options are often vanishing and flexibility is starting to disappear. Like I said, options start to shrink if they wait too long, or business owners will often then rush into a Chapter 7 because they think it's simpler. They just want relief, and by the time they act, they just don't have the cash on hand anymore, and the debt's ballooned, and reorganization just looks like it's not possible. But Chapter 7 is not always the best tool for business owners, especially if the business could reorganize or sell as a going concern. If you wait until the cash has dried up, this eliminates the ability to pursue any kind of restructuring that could preserve value through Chapter 11 or even a small business subchapter 5. If you file early enough, before judgments have been recorded or garnishments are in place or foreclosure starts, then the bankruptcy stay will automatically stop those actions, and this gives you some negotiating leverage. But if you wait until after aggressive collections have starts, you've already got foreclosure auctions that have started or are scheduled, or maybe your landlord has already initiated evictions, those types of things, then at that point, bankruptcy can't really undo many of the actions that your creditors have already started to take. And your ability to preserve business value or to restructure the debt becomes weaker. Bankruptcy is a snapshot in time, but if you wait too long, where you may have also qualified for a Chapter 7 or a subchapter 5 earlier, if you've waited too long, then you may no longer qualify or meet the eligibility requirements for those particular filings. Waiting too long may also result in generating new liabilities that complicate a clean filing. You may have assets that were exempt or protected that have disappeared. And so my recommendation to owners really is to start the process early. Don't wait until you're in crisis mode. That will give you greater flexibility, more options, possibly for reorganization of the business, and you can put yourself in a better position rather than finding yourselves stuck in the least desirable path, just simply because you waited too long.
Yeah. Don't wait too long. Great advice in life in general, right, Mike? Micheal, I appreciate the time, the insights. Thank you for all of this. Again, appreciate it.
Thank you again for having me, Mike. I appreciate it.
And thank you to everyone out there for listening to this installment of the Las Vegas Business, Bankruptcy, and Construction Law Podcast. You heard Micheal explain it there, but navigating the legal landscape of construction, business bankruptcy, it's rarely a solo journey. May Brock Law is here to help you and to ensure your next move is a confident one. If you found today's discussion valuable, do me a favor, visit maybrocklaw.com. If you want to schedule a consultation with Micheal and the team regarding your specific legal needs, they can help you there. And as always, before you go, hit like, subscribe, leave a review and comment, or share the episode with someone who needs to hear it. I am Mike Leon. We will see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.